many of y'all are starting out completely from scratch? Nobody. Everyone's got, oh no, okay, that's awesome. Okay, so first tip, find an attorney. I mean, I know everybody hates attorneys, but you really need to find someone that you like, someone that you can actually talk to. Because every now and then you're going to need to talk to someone, and that's a good thing to have that relationship with an attorney. I have one client, they had a bulldog attorney. Client, nicest guy in the world. Wants his company to portray that nice image. Bulldog attorney, not so much. Because your attorney will go off and be mean if that's their personality. If you don't want that for your business, you found the wrong attorney. So you need that relationship. It's just healthy. Every now and then, you're gonna need someone to pull your ass off the fire. So, the other thing, when you're starting out, start an entity and have your attorney do it. I've had some clients that did it on their own. Sometimes a perfectly legitimate way of going about it. I had one client in particular, they had a jewelry business. They set up their LLC on their own, and then somehow or another, someone thought that they were infringing them. And so they sued not only the LLC, but because of how it was filed, they also sued business owners personally. And at that point, your house is on the line. The whole point of setting up the LLC, the corporation, is to keep your house from being on the line. But since they didn't know what they were doing, that became an issue. And luckily, everything worked out perfect. Insurance took over. This other thing, business insurance. Business insurance will also be a lifesaver at times. But you don't want that. You don't want to have to deal with attorneys for 2 years because some crackpot thinks you're infringing them. Okay, so to IP issues. When you're starting out, you don't always understand patents. Patents have deadlines. So, understand patents. Most of the time, you can get in early and it's fine. But patents have a 1-year deadline when you start telling people about your invention. There are other issues with patents that come up, but having a good foundation, enough that you can think, oh, wait a minute, I need to go talk to an attorney about this, or I need to take this course of action, is good when you're starting out. You don't want to miss those things. And sometimes you don't need a patent, but at least knowing that foundation can help you sleep at night or prepare you for later on when you're a national company or in Walmart. Does everyone know what a patent is? Anybody not know what a patent is? Okay. So patents cover useful items. There are 2 versions of patents in general for y'all. There are design patents, and then there are what are called utility patents. Utility patents cover how things work. So you think about how your phone works, things like that. All the software, to some extent, is patentable. Camera, touchscreen, things like that. The way your phone looks, that would be a design patent. Design patents also can cover the actual products that you have. If you have a water bottle, that can be a design patent. There are also ways of manufacturing your products that can be covered by patents. But the areas of IP can merge and become very gray. Trademarks also can cover how a bottle looks. So, in early stages, when you're thinking, okay, I need to get on the shelf, I can't pay for a patent right now. Patents tend to be fairly expensive. There are other ways of potentially looking at the way a bottle looks and thinking, okay, if I make it have these little curves and flare out the bottom and don't make it look like a Coke bottle, there are aspects here that could be trademarked later on. Once people immediately, when you think of Coca-Cola, some people think of the bottle itself. So those are trademark issues that can set your business apart. And that's really what you want to do no matter what. When you think about how to get on the shelf, how to be viral, things like that, you're going towards the same goals that an IP attorney wants you to be going towards anyway. You want those things that call your product out. You also want your attorney to be aware of those things that you want to call out. That brand identity that you're trying so hard to push, it's good if your attorney knows what you're pushing too. Because they can set you up in the right path. I've had some clients call before and say, oh, I've had this product out for years. It's been out for 4 years. I want a patent. You're outside of the 1 year time frame. That's not really a possibility anymore. But you've also had that product front and center on your website for years. You push at it. You say, oh, look, this is my product. Think about what can Brown do for you. I mean, there's these things that businesses push that are trademark, and they can merge out and protect you even if the other properties are no longer available. So having that relationship, that plan in place, can be very beneficial even if you're on a shoestring budget. When early on people get these concepts of what they want for their company. Some people fall in love with the trademark name of their business. It's very important to do trademark searches before you start using that trademark, before you fall in love with it. It is just a name. I had a client 2 summers ago now. They didn't do a search. They came out with an electronics product, one of those little sticks that goes in the TV. They were real early on, and Roku had just come out. They were before Chromecast. It looked like everything was going great for this client. One of the other stick companies also came out and started using the same trademark roughly the same time. Massive battle over who gets to use this name, all of that. I think it bankrupted both companies. I mean, it's just this horrible thing because no one did a search. And on the other side of things, when you do the search, you file for the trademark too. Because there are some times when having a trademark filing can help you. I have another client, they're small player in the market are starting to come up. Big player in the market's out there screaming, wait, no. You're using this initial. This is our initial. We're going to use that forever. And they've been screaming about it, but our client's been using it for 10 years. They don't have a trademark filing on the letter itself, but in all of their other trademark filings for the last 20 years, it shows that letter front and center. So we can go back and say, look, we've been doing this 20 years. Stop it, go away. And they did. So but there are things like that you don't really think about. You can't always file for every little thing. Most people don't file for a letter because it's a letter. They want to be known by their actual company name, the thing that they're putting out, the thing that people say, oh, I want Starbucks. And you don't think about an S for Starbucks, you think mermaid, Starbucks. Not Starbucks, by the way.
West Rock.
Huh?
West Rock.
Yeah. Still good. The lesser used property of intellectual property is copyright. Should be used more. Most people don't use it because they don't really, they don't see a lot of value in it. And a lot of people don't respect it. That's the problem right now with the instant downloads and things like that. I talked to a company last week, gone through this big marketing plan, and there's all these pictures all through the marketing plan. Well, where did you get that picture? It's really great. It's awesome picture of your product. Oh, that's not really our product. I just found that on the internet. Oh, awesome, because yeah, did you get rights? Oh, well, we didn't get rights for that one. We did get Creative Commons on this one. Was it Creative Commons with like right for commercial use? What are you talking about? Oh, okay. So all of that marketing pitch is now without pictures. Which isn't a huge thing now because it hasn't actually been out in the marketplace and things like that. But it would have been if it had launched, because if you think Getty doesn't keep track of its images, they do. They actually know to the number how many times a picture should be released. And they will call you, they'll send you a letter. Most of the time they want $1,000, something like that. And I get a phone call, oh, shouldn't I fight this? Shouldn't I negotiate down? Negotiation with that will take more expense than just paying the grant. When you're on a shoestring budget, can you afford $1,000 out of your pocket for just using a picture that you could have taken yourself? So copyright is one of those things you need to understand. You need to do your own homework with copyright. That's essentially the goal. I mean, we learned that in school. Take your own pictures, write your own ad copy. Don't use inspiration from other people, because then there's copyright issues there too. It's one of those things that's one reason I don't have pictures in my presentation, because even though it's fair use is still a defense. You're still in copyright litigation. You don't want to be in copyright litigation. It takes 2 years, and every time you infringe a registered copyright that was registered before you infringed it, you face the risk of $750 up to $32,000 per instance of infringement. That's on the net. They will go, and I say net, everyone makes fun of me in my office, but if it's on the internet and you're in litigation, they will go to your ISP, see how many times someone went to that website, extrapolate that out to how many times someone saw that picture. That's a lot. I mean, there's a reason why when the recording industry goes after people for illegally downloading, it's messy. I sound very harsh when I talk about copyright damages because it can be bad. There was a little girl in Tennessee that got hit with $1.7 million. She downloaded 17 songs. I mean, that's it. I get way more harsh with the high school students when I talk to them because they actually tell you what you downloaded in the court documents. And so if you downloaded share, it's public knowledge, and that's not so cool if you're 16. But it's one of those things that copyright litigation is messy, it's painful. I had a client, luckily it was a good side, not one of the crash and burn stories, but this was a good one. She's an artist. She has her work registered ahead of time. I love it when artists have their stuff registered ahead of time because a big box retailer put it in their store, they put it on their website, and they didn't give permission. They didn't pay her for anything, and that design is dead on knockoff. So she gets a nice little settlement check, and that made her happy. But these are the things you do ahead of time. You get the registrations. Copyright is dirt cheap. If I do it, it's a little bit more. But the filing fee is $45 to $55. You can do it on your own. The Copyright Office, of all the offices in IP, is the most helpful. And I used to say, they would never give you the same answer twice. It's not so true anymore. They're getting better. I'm so happy with it. But they're very underfunded. They are very polite. They will help you. It is one of the easiest processes. You can do your website. You can do your packaging, copy. You can do a lot with copyright. You can even do 3D things like lamps or toys. Things that have artistic elements to them can be protected by copyright, even if they're not what you normally consider. And you'll be surprised how many times a catalog is knocked off. And I don't know how many of y'all use catalogs anymore, but websites are knocked off. I've had 3 or 4 in the last 2 years that people call and say, there's a dead-on ringer for me. And bloggers use content all the time, and sometimes when you use bloggers, you want them to do their own work. So that's another thing that you need to be careful of. It's one thing when you're doing your own work, you need to be careful that your employees and all your outside contractors also abide by copyright. It can be messy and it's hard for you to check, but sometimes doing a quick little quotes thing into Google and popping in some of their content to see if it pops up at all is useful. You can do image searches even. If that big box retailer had done that little t-shirt design, they would have saved themselves quite a lot of money. So, don't use clip art. Never use clip art for websites. Not only does it look ugly, Microsoft does watch that stuff. But, one of the last things I have before I see if anyone actually has any questions for me. How am I doing on time? Okay. Truth in advertising. It's an entertaining area of law. The Trade Commission, Federal Trade Commission, is over advertising. They are shockingly strict on it. So much that Red Bull does not give you wings is one of those things that you do not want to, yeah. There are issues with the American populace at times, but you want to say what your product does. You do not want to embellish what your product does to the point that people might actually get the wrong impression. The Trade Commission does go after people. You do not make health claims unless you can back it up and actually have the science and with you. They will ask you for it. And it gets messy. It's not one of those areas that you want to be in. They will observe you for years on end, usually 10 years, something like that. That's a long time. And if you break any more of the rules, the penalties are incredibly harsh. So it's one of those things you want to abide by. Again, that doesn't go for just your print copy. That goes for your social media usage. So if you're on Twitter and you're using a sponsored post, they want you to acknowledge that it's a sponsored post. The Trade Commission is like the Copyright Office. They put out a lot of information. I never actually had to call them, but almost all of their documentation, it's easy to read. They have brochures for truth in advertising, advertising on the internet, advertising in social media. Go and look at it, because it at least gives you a background that you can use for when you get to that point where you're using sponsored posts, or if you're there now, you need to be acknowledging that. They are cracking down on it more. Since I mentioned social media, the other issue with that is trademark and social media. Have your own trademark registered. If you get it early and someone tries to put it on social media, most of the social media platforms allow for ways for you to take it down. If you don't have it registered, that's a problem. And then you have a dummy site up there, it can be difficult to shut it down. The other thing with domain name squatters, those will pop up, and there's a way to shut that down if you have the registration early enough. It's better to be proactive with IP than it is to wait and sit back.
Okay. Meredith has to leave, so she's not going to be able to stick around for the reception.
I'll be back for the reception.
Okay. She does have a few minutes if any of you want to talk to her about and ask questions. I mean, there are other things about this copyright and this trademark. How many of you are familiar with Crystal Bridges, which is a big art museum right up the road? Interesting thing about Crystal Bridges, when they originally, it sets on Crystal Creek. So originally Alice was going to name the museum Crystal Creek. They did their due diligence, went out and searched. Crystal Creek is actually the name of a feminine hygiene product in Europe. So there are more reasons than just having to worry about what you're confusing your brand. If you go out and launch your brand and you don't do your research, there's no telling what you could be aligning your brand with. So there are international repercussions. So any questions, and I know some of you like Paul over here who has a product in HBA, those rules get a whole lot more complicated. Those studies become a whole lot more expensive, and there's wording you can use, can't use, to make sure you don't have to spend millions of dollars on research to go prove and put the science into it. So you got to do your work on the front end. So any questions for Meredith?
Yeah, I got an example. So let's say a company like me, Arctic Stick startup, I have a provisional patent that's meant for utility. 2 months I'll know if I have an actual patent. If a huge company took my idea and went forward, how hard would it be for me to fight them? And how willing would a lawyer be for working on success, basically a percentage? Because I always think, what if a big company did do that? They would keep me in court because they have millions of dollars and I don't. So I guess, how hard would that be?
Mark on your packaging patent pending. That is a crucial thing when you have a product that is actually patent pending, or when you have a trademark, you want to use the markings appropriately because that affects damages. And that's where it comes to when you have an attorney that you're going to want to take it, I'm assuming, on contingency. Those are issues that come up. If you can't get damages, there's not going to be anything in it for you to do it or for the attorney to do it. It depends on the people. I mean, you think large company that they can fight it tooth and nail. There are bad PR associated with patents and patent litigation. Even big companies trying to avoid that PR. It's one of those things, it depends on who you're going against and what's occurring. No one wants to be in litigation. It doesn't matter if your product is what's being knocked off, you don't want to be there. It is messy and painful, and it sucks up 2 to 3 years of your life. And to say it is emotionally draining is putting it lightly. There are ways against stopping litigation. There are negotiation tactics, and companies, no matter how large they are willing to negotiate and make the problem beneficial to everyone.
And there are certain things too, and I know this is one of your clients that I have some experience with. There are patents and trademarks on specific products. Dr. Peppermint, which is a mint company that is based in Fort Smith, it is a peppermint that tastes like Dr. Pepper. They launched it. Who do you think came in and sued? And it didn't turn out in Dr. Pepper's favor, right? I mean, I know you probably can't say much about it, but my point is, from what I do know of the case, Dr. Pepper owns the right and branding on carbonated beverage. They do not own rights on mints.
But
So,
that is a specific, really weird thing. There are times when we have famous brands, Frito-Lay, and we think about these brands and they become so big. When someone comes along and does Frito-Lay dog treats, Frito-Lay gets mad, even though no one's going to confuse the two. There are issues there, and so we don't want that blurring, or in Frito-Lay's case, they say tarnishment, that you don't want that issue coming up. So it is very important for you to know why you're picking a mark and what else could potentially be out there.
so back to doing your research.
Yeah.
So your brand doesn't get confused. Okay, Meredith, thank you very much.